everyone. Thank you for joining us today. This is World Law Group's Antitrust, Competition, and FDI group hosting today's meeting. And Brooke, if I could ask you to mute folks as you see them unmuting. Thank you. For those of you who don't know me, I see we have a lot of new folks that have joined us today, as well as some of our members who have been attending the antitrust group meetings in the past. I am Hannah Shea, the Director of Business Development with World Law Group, and I work closely with all of our practice and industry groups, of which the antitrust group is one. Just for your information, we are recording this session today, and we will share it with folks who have requested that won't be able to join us. So just wanted to let you know. We would appreciate if you renamed yourself to include your firm name, so that way if you have a question, we know where you're from. You can do so by finding your own video, hovering over it, clicking the 3 dots at the top, and there's a rename button. Or you can find yourself in the participant list, hover over your name, and there's a more drop down with a rename, and you can include your firm name. As you see, I have already done for the speakers. If you have a problem with that, you can just send me a note and I would be happy to help you with it. With that, I am going to hand it over to Harold at CMS Germany, who is one of the 3 co-chairs of our antitrust group. Harold.
Yeah, thank you very much, Hannah. I'm glad to see so many of you in the webinar. My warm welcome is also in the name of the other 2 co-chairs, Marcelo Cagliari from Tosini Freire from Brazil, and Scott Yu from Zhongli Law Firm in China, and myself from Harald Kahlenberg from CMS Germany. I'm glad to have so many of you in the call. The number is going up. We have 71 registrations, including the speakers from 35 World Law Group member firms, which we consider to be very good. And the reasons for this are certainly the interesting topics, but also last but not least, the speakers. I will briefly introduce the speakers and topics. Scott has then the important and difficult task to make sure all speakers are just in time, and Marcelo will then wrap up the results. We will start with Australia. Thank you very much, Jeff and Hayden, for joining us. You are members of Minter Ellison, the Australian law firm. It is 10:00 p.m. in Sydney. So thank you very much. You will speak on the new mandatory and suspensory merger control regime, which will start on 1st January 26. Then this will be followed by Debbie Feinstein from Arnold & Porter, the World Law Group's member firm for Washington, D.C. She will talk about how the US authorities under the Trump administration are enforcing merger control law in the US. Thank you, Debbie, for joining us. I have special memories, particularly because our case, which ended briefly before you became the competition commissioner of the Federal Trade Commission under the Obama administration. You have been antitrust lawyer for more than 40 years, worked with Arnold & Porter, went to the FTC as the assistant to the competition director, came back to Arnold & Porter, then were competition commissioner, and came back to Arnold & Porter as head of the antitrust group. So you are the perfect person to describe this. My excuses to the other speakers that I don't present them in such an extensive way. We will then have a talk from Mariam Sabet from Al-Tamimi. That's the World Law Group member firm for the United Arab Emirates. She will speak about the new thresholds of merger control in the UEA, and she is also the contact person of Al-Tamimi for antitrust and competition matters in all Middle East countries in which Al-Tamimi has offices. And finally, there will be Elisa Götz from my team at CMS Germany. She is a German qualified German-Italian. She will talk about the new call-in rights which exist or under discussion in some merger control regimes of EU member states following the judgment of the European Court of Justice in Illumina Grail. And last but not least, my thanks to Hannah for all her efforts to putting this together. So have fun with the talks, and Jeff and Hayden, you have the floor.
Thanks very much, Harold, for that kind introduction, and very nice to see a range of familiar faces from the ABA and other forums, and also looking forward to Debbie's insights on where things are at in the US at the moment, along with the other speakers. Thank you all for making yourselves available at various different times around the world. As Harold said, my name is Hayden Flack. I'm based in Minter Ellison's competition team in Sydney, and joined by Jeff, who heads our competition practice out of Melbourne. We'll cover off the developments to the merger control regime in Australia very briefly. I expect many of you will be familiar, have some familiarity with the changes that are being proposed. Harold, as you flagged, from 1 January next year, Australia will shift to a mandatory and suspensory regime. That will be familiar to many of you on the call. It is a significant change for the business community in Australia, who are very familiar and accustomed to our informal regime that has operated for decades. So this will be a significant cultural change for the community here in Australia. I'll circulate some written materials after the session today, which will provide some more details. But I think in the short time that has been allocated to us, I wanted to provide a very brief recap of the key features of the incoming regime, to talk briefly about some of the key developments and areas that remain subject to ongoing consultation, and finally to touch on some of the transitional arrangements and practical issues that we're navigating with clients at the moment. I'll charge on through, and Jeff will no doubt chip in with further thoughts. And I should say Jeff has been closely involved with the Law Council's engagement with Treasury and with government on the development of the regime. So he might have some further insights on particular issues as we run through those different issues very briefly. So to cover off the regime that is coming into effect, it will have features that are familiar to many of you on the call. As I said, it will involve significant cultural change, not only for the business community, but also the regulator here in Australia. The key features are it will have a suspensory effect with financial penalties, and an acquisition will be deemed to be void if notification is required and there is a failure to do so. The ACCC will become the primary decision maker, unlike our current regime, which requires involvement from the courts if a transaction is to be blocked. It will be a far more structured process for notification compared to the flexibility that we currently enjoy under our existing regime. The incoming regime will have prescribed forms and fees, set information and documents that need to be provided depending on various market concentration thresholds, and other features that will be familiar to many of you on the call. The written materials will cover off the regime in a little further detail, but the thresholds are, I think, what everyone will be most interested in for present purposes. They are turnover and value based, and at the moment they are subject to ongoing consultation, even though the regime will commence on a voluntary basis from 1 July. They are yet to be finalised by the government. There are 3 key thresholds that will apply to the acquisition of shares or assets. There is a general threshold where there is combined Australian turnover of $200 million, and where the target has Australian turnover of $50 million, or there is a global transaction value of $250 million. In addition to that general threshold, there are 2 additional thresholds that are designed to achieve particular policy outcomes. What the government is calling a large acquirer threshold, which is designed to target so-called killer acquisitions, and also a cumulative threshold that is intended to capture creeping acquisitions. It involves the aggregation of transactions that involve the same or sort of substitutable goods or services from transactions in the prior 3-year period. There will likely be further notification thresholds added over time. This includes specific industries that are a focus here in Australia. As will be the case in many jurisdictions, supermarkets remain a real focus area for the ACCC. They've also flagged other industries, including liquor, oncology, and other areas of the healthcare sector, those sort of sensitive industries. We're also anticipating a further notification threshold for transactions involving a 20% interest in unlisted or private companies, where those monetary thresholds are also met. And this is designed to avoid control-related questions or any attempts at anti-avoidance. There will be a range of exceptions that apply, including for land-related acquisitions in certain circumstances. So that's the quick summary of the regime. I think just to cover off some key developments and areas of ongoing consultation that are worth being aware of. As I said, the notification thresholds are yet to be finalised, and several concepts that are important to those thresholds have been heavily contested, and there's been significant pushback from the business community. For corporate groups, without going into any detail, the concept that is currently used of connected entities is imprecise and very broad. As I mentioned, Jeff has been working closely with the Law Council on some of these issues, and there has been advocacy to have a number of those key concepts, including that idea of connected entities, to be narrowed to related bodies corporate or other concepts that will be familiar to those in the EU along the lines of a right to manage. There are other issues that are still being consulted on around the approach to calculating turnover and how they sit with general accounting practices. What's been proposed is unnecessarily complex and may present challenges for foreign businesses looking to invest in Australia. Again, those are areas where we expect there'll be some shifts in the final regulation. There's also been, the regulations have been framed on the basis of businesses carrying on a business in Australia or having an intention to do so. Again, a very vague concept, and one where we expect there might be a shift in the final form of the regulations when they are released. There's also ongoing consultation at the moment around filing fees. The fees that have been proposed are significant. In some cases, initial fees at the moment for early stage notification waivers and simple reviews are relatively minimal, with $8,000 Australian or $56,000. However, for more complicated reviews at this stage, the proposal put forward by Treasury is approaching 1 million Australian dollars. And we expect that there will be real pushback on that issue, and perhaps, we hope, a move to more of a sliding scale aligned with the approach that's taken to FDI issues here in Australia, reviews by our Foreign Investment Review Board. The ACCC has also released updated merger guidelines that have not been substantively refreshed for 15 years. So that will be a significant shift where the ACCC has sought to engage with more emerging theories of harm and how it intends to approach reviews of those types of issues. We're also expecting further consultation on additional guidelines around the ACCC's public register. A significant change compared to current processes is that almost all transactions will be listed on a public register, even those that are subject to a notification waiver process. We're also awaiting further information on the interaction between the work of the ACCC and FDI processes. So lots still to come. The final issue that I wanted to cover off very briefly in the remaining couple of minutes were the transitional arrangements and some of the practical issues that we're dealing with clients with at the moment. As I said, while the regime, many aspects of the regime have not yet been finalised, it will operate on a voluntary basis from 1 July alongside the informal regime for the second half of this year. At this stage, this means we're navigating some strategic filing questions with many clients who are looking at transactions that will sign in the second half of this year but may not complete until 2026. There is optionality for applicants to use the current informal process to gain protection for the incoming regime in the second half of this year. The ACCC has flagged that those informal notifications will be considered, but from around October, there is a significant risk that those reviews will not be completed by the end of the year, and any ongoing reviews as at 31 December will result in a no decision that will require a refiling. So we're expecting to see an increased push for filings in the pre-October period for parties seeking to gain the benefit of the current informal regime that will provide protection for a period of 12 months into next year. We are also seeing increasingly complicated CPs being structured as part of transactions to ensure that there are protections on both buy and sell side in terms of how parties are going to engage with the ACCC during the transitional period. So there is some need to consider bespoke drafting at this time. Two final issues that I did want to flag briefly. Restraints. We are expecting an increased focus from the ACCC in relation to restraints and how they're framed in transaction documents. There are some specific provisions under the incoming regime that are different to how we deal with those issues at this stage. So expect due diligence processes and drafting to focus in on what those restraints look like and how they're framed. And as I've mentioned FDI on a couple of occasions, and I'm sure a number of you will be interested in relation to FDI issues, the interaction between the ACCC and FIRB is one that we are continuing to monitor. We expect there will be ongoing interaction and that the ACCC will use FIRB notifications as a check-in mechanism to ensure that transactions are being appropriately drawn to its attention. So I think those, in the sort of 10 minutes that we had allocated, those are the key issues I wanted to cover off. Jeff, I'm not sure if there were particular issues you wanted to mention. Otherwise, happy to take any questions, or I'll defer to you, Harold, if we're dealing with questions now or at the end, but happy to take questions now or deal with them by email afterwards. Jeff.
Yeah, thanks, Adnan. Excellent summary. Just a couple of points also to note. For below threshold transactions that are not required to be notified, it's worth noting that there still is a residual merger control provision, which is the same as the current one. So there is the possibility of risk for smaller transactions that are found to have a substantial lessening of competition that enforcement action could still be taken. That can be ameliorated by potentially filing on a voluntary basis. But otherwise, I think the key messages really are, with respect to transaction planning, if there's any risk that the thresholds will be exceeded with respect to Australia, and closing of those transactions might push into the 2026 calendar year. It really is time to think about what the appropriate approach is in Australia and what the most efficient way to get those clearances are. And obviously, as soon as the government has finalised the technical aspects of the calculations and so on, we're very much here to assist our friends in the World Law Group to deal with those and to build up your multi-jurisdictional playbooks so that you can have a confident view as to what's likely to happen in Australia. But I'll leave it there, and yes, very happy to take questions.
All right. Thank you very much, Hayden, Jeff. Yeah, that's amazing that you can speak like so much information for us at such a short time that you have, and we look forward to the materials that you are going to circulate to the group. Thank you very much. So I think next we're going to move to Debbie first. Then Debbie, as Harold has already introduced, is a veteran in this area, and she's going to talk about the new trend for the antitrust law enforcement in M&A. Thank you, Debbie. Stage is yours. Debbie, you need to unmute yourself, please.
Thanks very much.
Here we
So
go.
10 minutes to cover everything that's going on in the US. I'll try to give you the highlights because it's been a time of significant change, and we're just talking about antitrust and significant change. First, the Federal Trade Commission, as we know it, is not what we used to know. The Congress set up the FTC as a bipartisan commission, and no more than 3 commissioners could be of the same party. President Trump has changed that. He has decided that there should be no commissioners he doesn't like. And that means that he fired the 2 Democratic commissioners. They are appealing that decision. They are litigating that decision, but based on some other rulings, it's questionable whether or not they would get their jobs back. One of them resigned because he needed to go find a job where he could make money. So even if that lawsuit is upheld, it's not clear what happens to the commission. The second thing is that there are rumors that he's going to move one of the existing Republican commissioners to be a U.S. attorney, and who or whether he would replace somebody else is unclear. So right now there are 3 Republican commissioners. The chair is very hard to predict. In some ways, he sounds like a conservative Republican in terms of wanting to make things business friendly and wanting to make decisions expeditiously. In other ways, he sounds not a whole lot different than the most liberal of Democrats when it comes to antitrust enforcement. He definitely talks about going after high tech a lot. Commissioner Holyoke is kind of a mainstream, middle of the road Republican. And then Mark Mader, the other commissioner, is a former staff attorney, worked for a very conservative senator, but some of the things that he says suggest that there should be increased antitrust enforcement. So how they will come out is very unclear. A little more predictability at the antitrust division, where Gail Slater is a well-known individual. She works for the Federal Trade Commission as well. She seems to be mainstream enforcer, middle of the road, but we'll see. It is early days. One thing that I think surprised everyone is that the 2023 merger guidelines, which the Democrats put into effect, and remember, this was at a time when there are no Republican commissioners at the FTC, so it was not bipartisan as all of the other merger guidelines have been. Those merger guidelines are staying in effect. This is a surprise because the merger guidelines say things like every merger with a market share of 30% is presumptively unlawful. That is not how the government has ever enforced the antitrust laws. It's not how Lena Khan enforced the antitrust laws. And I'm confident that not every 30% deal will face a challenge from this administration, but the fact that they left them in place is interesting. I think it's going to take a while and some speeches to learn how it is they're actually going to enforce the antitrust laws. Since since the new administration has come, there have been a couple of things that they have done. One is they have continued to bring lawsuits. That is no surprise. The Department of Justice sued to block the Hewlett-Packard Juniper transaction. It's, according to the allegations in their complaint, a merger that reduces the number of competitors from 3 to 2. So on that level, not particularly surprising. What is surprising is that it combines number 2 and number 3 for a combined share of under 30%. And some have expressed surprise that they would challenge a merger with such small shares. Their response is it's a duopoly, create a duopoly, and the leader has a very high combined share. The defense is arguing that it's in fact a worldwide market, and so there are many other players, and these shares are not valid. So we'll see how that one turns out. Trial is, I believe, in the fall. Then the FTC also sued to block. Actually, I'm sorry, the trial is coming up in June. Then FTC also sued to block. This was a unanimous decision back when the Democrats were still there. This complaint charged that the combined company would control more than half the market for outsourced hydraulic coatings, which are used for medical devices. So again, at least looking at the complaint, nothing particularly unusual or surprising about that transaction. A couple of things that have happened that make us think that we might be going back to the way things are. First, as you'll recall, the government has 30 days after a transaction is filed to decide whether or not to issue a second request. Typically, they will grant early termination of that waiting period if they decide there are no problems. That was suspended during COVID, which really, frankly, did not make a lot of sense to me. The argument was, well, it's COVID and we're overloaded and people aren't in their offices and it's much harder to work. And so we can't grant early termination. It doesn't actually require additional work to grant early termination, other than a couple of phone calls. So the idea that, well, we need more time to decide, if you did need more time to decide, just on that particular merger, take the more time. If you don't need it, you could grant early termination. But they put an end to all of it. And I think that was really more an issue of them not wanting to kind of acknowledge that any transaction didn't raise concerns. They just wanted to let the waiting period expire. Early terminations are back, and they're back for real. We've gotten early termination on transactions involving competitors where there really was no issue at all, but the kind of deal that might have gotten more of a look before is now being granted early termination, again, because there really are no issues. So that's a good development. The second thing is both agencies repeatedly said that they were going to be more consent friendly than the Biden administration had been. Both the FTC and the Department of Justice during the Biden administration were highly, highly skeptical and critical of consent decrees. That always surprised me because when we did a remedy study, when I was at the Federal Trade Commission, we found that more than 80% of remedies were successful. And while that's not perfect, and we learned things about what might be done differently to make remedies even more effective, 80% is a higher win rate than the government had in litigation during the Biden administration. You're never going to have perfection in remedies, is my view. And the alternative is you may bring a lawsuit and lose and get no remedy at all. So this government has gone back to saying we're going to accept remedies, and they've done so. Each of them has required divestitures in recent mergers. And interestingly, the FTC did not require what's known as a prior approval provision in their consent decree, as they had during the FTC. And prior approval means that rather than the FTC, the normal process where you file your Hart-Scott, the government reviews it. If they have a problem, they challenge it in court. A federal court judge decides whether or not to block the transaction. With prior approval, the FTC gets to decide, and they can take as long as they want. They don't ever have to make a decision. They get to wave a magic wand, something that normally they cannot do. And that was really an impediment to people wanting to enter into a consent decree, even if the government had been willing to do so, because they didn't want to turn over future deals to the FTC deciding up or down and wanting to leave it to a federal court judge. So those are developments that I think the antitrust bar has welcomed, that consents are back. It gives you more options. The final thing I want to mention is that the agencies put in new Hart-Scott requirements. The form that was the same pretty much with minor exceptions since the beginning of the Hart-Scott Act in 1976 has been changed pretty dramatically. And the key thing to remember is it's going to take more time and more work. The old Hart-Scott used to be kind of like your tax preparation form. You filled out some numbers, you filled out some basic information. There was no narratives other than a description of the transaction, which was easy to do based on the agreement. It was the kind of thing that you could hand off to somebody, and the people working on the substance of the deal really didn't need to get involved in. That's not the case anymore. First, they want a lot more by the way of documents, both documents about the transaction. They want them from a lower layer than they used to want them. More importantly, they now want ordinary course business documents, sort of thing that they got later in the process, they now want upfront. So those presentations, those board decks that talk about the business, they all have to be produced. Now you have to do more narratives. You have to do a narrative of the overlap. Now, this isn't a whole product market discussion. This isn't pages and pages like in an EC form CO, but it's enough to identify whether or not the parties compete in some respect. You also have to do a narrative and give information on whether there are any vertical relationships between the companies. You have to put in information about whether or not there are any what are known as board interlocks, any officers or directors of companies that are officers and directors of competing companies. They want information on whether or not you accept foreign subsidies. They want more information on minority shareholdings. There's just a lot more to this. So these have become more burdensome, more time consuming. They're not quite as bad as I feared they might be, but the kind of thing that you could routinely tell a client you could get done in 2 weeks is now easily taking a month or longer and requiring a lot more resources. It doesn't seem to have materially affected how the agencies are doing their business. I don't think we're getting questions on deals we didn't think we would simply because they have more information. And in some deals, it may speed things up because now they're getting upfront information that they would have asked for only a week or two into the waiting period. What the ultimate effect is going to be is unclear, but at least for the moment, the Hart-Scott rules are here to stay. So happy to answer any questions through the chat now or later. But I think that sums up the highlights.
Yeah, thank you, Debbie. Yeah, that's right. We have also observed that recently a significant increase of the fee charged by our US consuls in those global transactions. I think the things are moving pretty smoothly. So we can probably open floor for questions for 2 minutes for both the Australia team and also US team. See if anyone has any question about the interesting introductions of the regimes in Australia that we have just discussed with Hayden and Geoff. Or any question for Debbie? Okay. Yeah, we can also do that later. But so now if there's no question for time being, let's move to the UAE regime.
Scott, there was a question there.
Yes, please. I'm sorry.
Juan Manuel.
Yeah, I'm sorry. I didn't see you. Yeah, go ahead.
Thank you very much, everyone, for the kind presentation. Debbie, I have probably a quite difficult question regarding the DOJ last guidelines, the one that entered into force on and around, I think it was January 2023, I believe, or something like that. The thing is that, at least in our countries, those guidelines about the 1,800 HHI threshold are for countries like Uruguay, which are very small. They are quite restrictive in terms of, obviously, shouldn't, in my view, be applied automatically in other jurisdictions, okay? I'm not saying that they are okay for US, but for other countries, they are normally very strict and very difficult to not reach that kind of concentration levels. So my question is there any plan, or it is envisaged the possibility to lighten a little bit those guidelines, or it should be maintained as they are for the foreseeable future?
Well, as I indicated, they specifically said they were not withdrawing the guidelines and they are staying in effect. I think they will exercise prosecutorial discretion a lot. Not every transaction that reaches 1,800 on the concentration index is going to be challenged, and it wasn't before, it's not going to be now. And remember, 1,800 is back to what it used to be. That's not a new number. It went up in the 2010 guidelines. It's going back down, and transactions that hit that level were never automatically challenged. They looked at a lot of factors, but at least from everything we've heard from this administration, those guidelines are staying.
Okay, thank you.
Could I add a question, Scott?
Yes.
Just Debbie, continuing with you, I had a question on the independence of the agencies, really. I mean, with what we've seen with all the people who were fired and the government the president making it very clear that he doesn't want dissent within the government, going so far as firing people who had terms. And by the way, just as a parenthesis, the FTC was a model, for instance, for the Brazilian Competition Authority to gain independence. It was the idea that the commissioners would have terms, so I had to go through a Senate confirmation hearing, and I had a term and couldn't be fired, modeled after that independence. Obviously, we're seeing that question now, but my point is maybe the way that Trump is dealing with that will remain in the future. If you have Supreme Court decisions that, for instance, overturn precedents that talk about the non-fireability, to use that word, of appointed officials for some, in some situations, that will remain for other governments as well, meaning that they can impose their will on transactions. We see all the discussion involving U.S. Steel and Nippon Steel. And do you think there will be more politicization of transaction decisions, both in this administration, but then that will have changed the standard, will have changed the bar for the future as well, and that is something that we're going to have to live with ongoing?
You know, I'm of a mixed view on all this because, you know, one of the great features of the FTC, where I worked twice, is its bipartisan nature. But on the other hand, the Antitrust Division has never been bipartisan. The Department of Justice has always been whatever party the president is, and except for very, 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 very rare instances, mergers were not very politicized. I think it got more politicized, frankly, in the last two administrations. It wasn't just the Republicans. I think the Democrats did something to politicize antitrust. I think what it means is at the FTC now, you may see some more of the pendulum swing that you used to see only at the Justice Department. But, you know, like I said, it's always been the case that the president could fire the attorney general or the assistant attorney general for antitrust. It just rarely happens. And now that's just going to carry over to the independent agencies, it looks like. So it's going to question whether there's even a need or a relevance to the FTC, which some are already questioning, because if there's not an independent agency, how's it different than the Department of Justice? And that's something that some in Congress are saying there really isn't a difference, and we should just move all the antitrust functions from the FTC into the Department of Justice. I don't think that's going to happen, certainly not anytime soon, but it'll be interesting.
Thank you, Debbie. Marcelo, any other question? No. Okay. Thank you. So we now move to Marianne. She will talk about, I think, the new threshold rules, please.
Yeah, thank you, and thank you everyone for having me. I think this is the first time I present before the WLG group. Currently in Dubai, so it's really, really different temperature than I think most where everyone is, different landscape. And I thought that maybe before I take you around the merger threshold that entered into force 31st of March, maybe I'll just take a little bit of a step back, because not familiar if everyone is familiar with the original background. And so historically, we had a law in the UAE that was dated 2012, pretty not very active. It was a market share threshold law. And so it was 40%, so you wouldn't capture lots of deals back then. And then something happened in our region, and I can pinpoint that to be 2019 particularly. That's when, and I call this the Arab Spring, so it's important to just get a little bit of the historical background. And so 2019, a shift has happened. Saudi Arabia started to change their competition laws, and they shifted from market share to turnover threshold, and that changed. They suddenly had 300 filings as a result that year. And then Kuwait 2020 said, okay, we're going to do the same. We're also going to have a turnover threshold territory. That's 2020. And then UAE came end of 2022 and said, okay, hang on, we're also going to do the same. We're going to change our laws, and we're going to change it to a turnover threshold as well. And so this is where we are at now with the UAE. End of 2022, they changed their laws, and the most significant changes they've done are mainly two or three. One, it became a regime where you could trigger a filing if you meet the turnover threshold. They also kept the market share. The trick was that at the time, they had not yet announced the value. So we knew end of 2022, beginning 2023, that there is going to be a decision soon on what those values are, but we don't know what it is. So we were in a limbo for a year. And then what they also did, what was really important, particularly in our region, is they've removed the sectorial exemptions. And so the 2012 laws just had exemptions pretty much for everything, every kind of sector you can imagine. They had exemptions for SMEs, and most importantly, they had exemptions for government entities, including those entities that are just 50% owned by the government. And so as you can appreciate, at that law, the 2012 law had no real teeth at the end of the day. And so there was quite a shock with these exemptions that came into that entered into force end of December. And so we start 2023, then we stay a whole year with no changes. I mean, no updates. What is the value of the turnover? We get so many queries, but we're still on the market share. So 31st of March of this year, the turnover threshold entered into force, and the value of the turnover that will trigger a threshold would be if the combined annual sales of the parties is 300 million dirhams. That's approximately $81 million. So that's not a lot. And or if you have a 40% market share. So they kept the market share, but they also gave a turnover value. Now the catch here is interesting because they've linked the calculation of the turnover threshold to the relevant market, and whatever that means, right? So this entered into, we've been the last 2-3 months analyzing in various different forms, how do we define the market that will be tied to the relevant threshold? And I'll come to you later on that, but I'll just continue with the latest changes. So this entered into force. So as a result, obviously, the authority went from having a couple of filings per week or per month to maybe hundreds of filings per month. Now they're really completely swamped with all the filings that have come in place. Another new addition that came in is under the old law, if you filed and you don't hear a response with 90 days, that was presumed to be accepted. They've changed that completely to be presumed to be rejected, right? So it does give an indication on what's the direction the authority wants to do and how strong they want to be. They also revamped their penalties. It became tied to an annual turnover of the companies in the UAE if for any fines of gun jumping or failure to file. And so you can see the direction is coming. This is part of the UAE's obligations towards international institutions such as the OECD. They're also keen to be seen as active in the region. And this is not just the UAE. And it's important for you to link it to the other Arab countries as well, because Egypt as well changed its regime to a pre-filing notification regime. It entered into force last year. The reason this is all happening, and you're probably asking why suddenly the Middle East is now coming really active in competition. It's because they all joined the Arab Competition Network. So it's a similar institution as to the European Competition Network. They all joined that organization and they're all member of it. And so I think it's just a matter of time before other countries will also follow and start changing their regimes. So these changes are here to stay. If anything, they're just going to evolve and become stronger. So back on the UAE point, and you could interrupt me anytime if I'm speaking too fast or if you have any questions, but just to recap, we now have a turnover regime that is triggered on turnover, if it's 81 million combined, or if you have a market share regime. What's not really helpful is there are a lot of ambiguities that relates to how do you define the relevant market. There's a definition, but there's no guidance. Timelines as well. It says 90 days. It could be interrupted. The clock starts when, we don't know. And all of these things, we're waiting for it to be clarified in the executive regulations. So this is the current suite of legislation that is still pending. Until this is issued, which is supposed to be issued this year, we're still currently using the previous executive regulations, which is not helpful at all. So if I am to recap what we're waiting for, we're waiting for the value of the filing fees because they're going to be filing fees imposed, but we still don't have that decision. We're going to wait for additional administrative penalties to be issued in a decision. We're waiting for the implementing regulations that will give you basically more formalities and discuss as well issues such as, is there going to be a short form? Are you going to ease the formalities? Because as we speak now, the formalities are really, really burdensome. They require legalization and translations. So there's been a lot of talks about they should remove these burdensome formalities, but until now, there's no decision on this. And most importantly, there's a lot of ambiguity on government exemptions. We've had so many queries on a lot of firms and clients because a lot of their clients, sovereign wealth funds and other government entities, have joint ventures or have 50% ownership in other entities. Historically, these were exempt. they're no longer exempt, right? So there's a little bit of misunderstanding of what do we do now with these government entities that are not 100% owned by the government. Another point, if you have clients that are government entities, just because you're 100% UAE government owned does not mean that you're automatically exempt. There, you actually need to be as part of a list that's issued by the cabinet or the Supreme Council of the UAE that says you are among the list of the exempt entities. Until now, there are 14 lists of government exempt entities, and I can share that list and circulate it with the group. If your client is not on that list, they're not exempt. That's it. It's very straightforward. And to be on that list, you need to actually make a submission and apply, and it could take months. So these have been, I'm just gathering all mainly the common questions and frequently asked questions that we had over the course of the last few months of this new regime. I think it's a lot to unpack, and we've circulated a little bit of a brief note. What I'll do is I could just recap some of these things, what we're waiting for, and maybe make a list of the frequently asked questions as well, like a Q&A type of note that maybe that could be helpful for everyone. And that's it for now.
Thank you, Miriam. Yep, that's very interesting. It's not just about the UAE. I think you also introduced the new development in your area. So now we are moving more west to Europe. So Alisa, she's going to welcome CMS Germany. She's going to talk about the calling rights of the EU member states. Please, Alisa.
Yes, thank you very much, Scott. It is a great pleasure for me to speak at today's World Law Group webinar about a very interesting development in EU merger control, the adoption of call-in rights in more and more EU member states following the EU Court of Justice's landmark judgment in Illumina Grail, and the remaining uncertainty we are currently facing after this judgment. So I would like to begin my presentation by giving you a brief summary of the ECG judgment in the Illumina Grail case. And next, I will focus on the call-in rights of the EU member states by addressing the problem of catching so-called killer acquisitions. So let's have a closer look at the Illumina Grail case. What has happened? Illumina, a biotechnology company, wanted to acquire the healthcare startup Grail. The transaction did not trigger any merger control filings in the EU or at EU member state level because Grail, being a startup, had no significant turnover at the time. However, a number of EU member states filed a referral request according to Article 22 EUMR, asking the European Commission to review the transaction. Let's have a quick look at Article 22 EUMR at this point. According to this provision, one or more member states may request the European Commission to review any transaction that does not exceed the EU merger control turnover thresholds, but affects trade between EU member states and threatens to significantly affect competition. Upon the referral request, the European Commission opened an investigation and finally prohibited the transaction. Nonetheless, Illumina and Grail closed the transaction before the Commission had completed its review, and in consequence, the European Commission imposed a fine of 432 million euro, which is its largest gun jumping fine ever, and ordered to divest Grail. The parties challenged the European Commission's decisions, arguing that the European Commission lacked jurisdiction over the transaction by applying Article 22 EUMR to a transaction that did not trigger any national merger control filing thresholds. In its decision delivered on the 3rd September 2024, the ECG ruled that Article 22 EUMR cannot serve as a legal basis for the European Commission to review transactions that do not meet any national merger control thresholds. In a nutshell, the ECG justified this ruling by interpreting Article 22 EUMR historically and also based on its purpose. Hence, according to the ECG, Article 22 EUMR referrals can only be made by EU member states having jurisdiction over a transaction with regards to the national merger control notification thresholds. This judgment was a severe blow to the European Commission's guidance paper on Article 22 EUMR, which had been published in 2021, and which addressed the problem of catching so-called killer acquisitions. Killer acquisitions are takeovers of smaller, innovative startups with significant business potential, just like Grail, by large established companies, just like Illumina, with the purpose to eliminate them as a possible source of future competition. In many cases, the startup will have limited turnover and hence falls below the relevant merger control thresholds. Yet the price paid for its acquisition can be significant. In its guidance paper, the European Commission encouraged national competition authorities to use Article 22 EUMR to refer transactions to the European Commission for examination, even where the transaction would not be caught by either EU or national merger control systems, in order to address a potentially existing enforcement gap regarding killer acquisitions. With the Illumina Grail judgment, this broad interpretation of Article 22 EUMR has been put to an end. However, the general fear that killer acquisitions might slip through the net of EU merger control regimes due to a persisting enforcement gap still exists. And this fear leads to an observable trend. More and more EU member states are introducing call-in rights in their merger control system. So what is a call-in right? A call-in right is a legal provision that enables a competition authority to intervene in mergers below traditional notification thresholds and to force the involved companies to file a notification. At the moment, the national competition authorities of Cyprus, Denmark, Hungary, Ireland, Italy, Latvia, Lithuania, Slovenia, and Sweden have already implemented call-in powers, which enable them to review transactions that fall below their national merger control filing thresholds. The number is expected to grow. So authorities in Belgium, the Czech Republic, France, Finland, Greece, and also the Netherlands have already voiced support for such powers and are contemplating the introduction of call-in rights to their merger control systems. The design of the existing individual call-in rights varies considerably. And I would like to give you just a rough overview of the different call-in rights. If you are interested in getting a deeper insight into a specific call-in provision of a certain EU member state, you can of course consult our group experts of this specific EU member state. But speaking broadly, we can roughly divide the existing call-in provisions into two groups. Call-in rights, which are subject to reaching a certain minimum threshold, either turnover or market share threshold, which of course is below the general national merger control thresholds. And on the other hand, call-in rights requiring the creation or strengthening of a dominant position or a significant restriction of competition. The call-in right of Cyprus is a great example of a very broad approach of a call-in right. The competition authority of Cyprus can review a below-threshold transaction if the Minister of Energy, Commerce and Industry declares a transaction as being of major public interest. Furthermore, there also exists a wide range of approaches regarding the issue of time limits for such call-in powers. Some EU member states, such as Sweden and Cyprus, have no time limits at all for making use of their call-in rights, whereas in other countries, such as Italy, Denmark, and Hungary, the deadline is 6 months after the transaction has closed. So what consequences are we facing due to the introduction of more and more call-in rights in different EU member states? First of all, merger control in the EU is becoming more intricate and unpredictable. Due to this Colin trend, companies face a fragmented, decentralized system shaped by the coexistence of various national merger control rules. Furthermore, the ECG left the very important question open if for an EU member state, having jurisdiction over the transaction only refers to the traditional national merger control thresholds or also to a national call-in right. According to the European Commission's current interpretation of the Illumina Grail judgment, the latter is the case. Hence, national competition authorities may also refer transactions to the European Commission under Article 22 EUMR when the transaction can be reviewed under their call-in powers. However, this interpretation is yet to be confirmed by the courts. But all of this leads to a great amount of legal uncertainty. So let's raise the question whether call-in rights are the only solution to face the problem of killer acquisitions. If we take a closer look at Germany, we can note a different approach. German merger control law introduced an additional value of transaction threshold, which allows the German competition authority to review transactions in which the consideration for the acquisition exceeds 400 million euro. This provision has been adopted to German merger control law to cover cases in which the target generates little or no turnover, but is still purchased at a high price. The high purchase price in such takeovers is often an indication of innovative business ideas with great competitive market potential. But not only Germany, also Austria has a very similar value of transaction threshold. Alternative solutions could be a reduction of existing turnover thresholds, either on national level or at EU level. However, it is very unlikely that the EU merger control thresholds will be reduced due to the very extensive notification requirements. Additionally, the ECG explicitly referred to its tower cost judgment and noted that member states may also have the possibility to review transactions under their national abusive dominance rules. However, such a review would be a very time-consuming post-closure procedure and would only be possible in cases where the acquiring company is indeed dominant and the acquisition of another company could constitute an abuse of that dominance. Finally, the European Commission could also push for amendments of the EUMR, which have to be carried out by the EU legislator. This already brings me to the end of my presentation. Thank you very much for your attention. My presentation will be made available to you afterwards. So if you have any questions, and if we have still some time left, I am happy to answer them now, but of course also later by email.
Yeah, thank you, Alisa. Now we have all four speakers finished and provided a very useful and informative presentations about their jurisdiction. I think we can still have a few minutes for questions for the second part. And also we will have Marcelo to make a close remark for this for today's meeting. Any question? Okay, let's thank you again for our speakers, Hayden, Geoff, Debbie, Mariam, and Alisa. Thank you. Very useful and very informative. Marcelo, you want have a few minutes before we close up?
I mean, I think everyone has questions. We're just looking and mindful of the clock and thinking that everyone has other appointments, and we like to be on time for those who are not usual suspects in our sessions. But I think this has been very true to World Law Group tradition of going around the world, seeing developments, and I think the picture that we are that we've seen is very sobering in a way. Lots of changes that require caution for companies planning deals around the world, and certainly for our corporate partners, who with whom we always have the difficulty of stressing the need to come to Antitrust Council in a timely fashion, especially now. I mean, we saw huge changes in Australia with the new whole new regime coming up. We've seen changes to suspensory regime. Certainly, we went through one of those in Brazil, and all the issues that it raises for the next many years, from the definition of group to the actual calculation of turnover, and how do you define effects? What is business in Australia, you guys mentioned, or someone intending to? Those are going to be very day-to-day issues that you're going to be facing with the next, and we will as well in counseling our clients in terms of determining where they need to go and what they need to wait for before they can close transactions. Obviously, we had this massive shift in the US in the administration. The impacts in antitrust themselves are less clear. We saw some continuation in things like the merger guidelines that we mentioned, or continuation of attempts to block deals in the courts. You would expect this administration to be a little more business friendly, and then you see early termination coming back, which goes along those lines. Remedy negotiations coming back, which go along those lines, but stronger and tougher HSR requirements, which go against it. So not a clear trend again in terms of how the change in administration will affect the day-to-day business of that. Also more yellow flags for people to keep aware of. We saw in the United Arab Emirates the strengthening of the regime, tougher fines, more filings happening with the new tests, which will also raise lots of questions, lots of issues, and the interesting information that's not only there, but it's also spreading around other Arab countries. So more things that we'll need to pay attention to when advising international transactions. And finally, call-in rights in Europe. Again, things that are spreading not only there, but in other places, raising the level of uncertainty and less and unpredictability that you have in transactions. I think all of the scenario is exactly why we're here. It's exactly what we do, is dealing with that uncertainty, with that complexity in this coordinated multi-jurisdictional way, which the World Law Group allows us to do in such a fantastic manner. So a lot of the resources that we have will incorporate some of these materials. We ask you guys to circulate them to the group, send them to Hannah. We have the website where you can actually post things that everyone will see, so you can get this enormous audience around the world to be alerted to the difficulties and be able to access you more easily in case we need to. So we certainly ask you guys not only to share the material, not only the people who are speaking today, but also everyone else, to share the material with our resources, but also to consult, to go in there and take a look. You'll find lots of interesting things that will be food for thought next time you're dealing with a new transaction, thinking, where do I need to go to properly advise my client? I think, again, this is the example of the kinds of things that the Antitrust Practice Group does. We're very happy to see you all. We'll certainly be in touch regarding next events that we organize, but are always very happy to hear from you guys as these changes unfold, and many of these things will be worked out or not in the next few months or years. But many thanks again for the participation, and especially for our speakers. Hannah, the unit close.
Excellent. Thank you, everyone. Thank you, Harold, for, of course, helping me organize this, and thank you to our speakers, Marcelo and Scott as well. As I mentioned, this has been recorded, and we will edit it and add it to the website so that you guys can circulate it within your firm for those colleagues of yours who are not able to attend. And with that, I hope everyone has a good rest of their day or evening.